Good afternoon. My first words on behalf of myself and all of us must be to thank our hosts for bringing us all together here, for their warm welcome, and for structuring our discussions to take us from the many questions which face us through to possible answers. Good answers depend upon asking the right questions. At this early stage of our gathering, I shall focus mainly upon questions. As we look around us here, we see both unity and diversity. Above all, what unites us all is that we are all human beings. Our fundamental needs and aspirations are universal. They are reflected in our internationally acknowledged universal human rights, shared with every human being on this planet. And we share the obligation to play our part in delivering compliance with those human rights to everyone. There is also splendid diversity in this room. Diversity in our starting points, our career journeys, our travels to come here. But we are hit with the first question upon arrival at a gathering about guardianship. Just as my aeroplane was a vehicle to bring me here, guardianship is at best a vehicle to deliver what? To take its passengers to what destination? And what is guardianship? If there is one lesson to be learned from the brief comparative summary, which I shall present shortly, it is that guardianship means as many things as there are countries which use the term, with further variation in how it is actually delivered. We should not start with a concept which is at best one answer and an uncertain one until we have formulated the question and the destination for which, for each individual, we may want to find the most appropriate vehicle. I offer you this formulation of that question. There it is. How can modern human rights compliant legal systems best respond to the needs of people who may require support in the exercise of their legal capacity and who may or may not be capable of proactively and validly exercising their legal capacity? In that formulation, proactively means not only making decisions about which there has been so much discussion, but identifying the need to act and acting, and in setting the agenda for decisions which need to be made. Validly means ensuring that actions, transactions, and decisions leave third parties with no doubts about validity, nor cause to hesitate or even refuse to accept and to act upon them. And we must be careful about the word support. Article 12.4 of the UN Convention on the Rights of Persons with Disabilities, CRPD, requires that relevant measures respect the rights, will, and preferences of the person. Importantly, preferences is in the plural. When we have to make a difficult decision, we often have to balance conflicting preferences. Even more importantly, those three elements may be in conflict with each other. Here's a simple example from my own experience. A young man had severe learning disabilities, sometimes with challenging behavior. He could communicate only through the interpretation of his behavior by skilled carers who knew him well. His behavior deteriorated. He aggressively resisted anyone or anything going near his mouth. His clear will was to stop any interference with his mouth. His preference was that the toothache which he had developed should end. His right was to receive appropriate health care. Support meant ensuring that he received treatment, using legal measures to assure the dentist that he could properly deliver it. The next few days will tell us whether we can find unity even in the questions to which our diverse systems seek answers. I turn now to three different diversities. The first is the diversity of reasons why such support may be required and of relevant factors. This was emphasized in a report less than a year ago by the Law Commission of Ontario. That diversity and the greater diversity of disabilities generally presents the danger of discrimination within non-discrimination, the danger that responses to disability focus too narrowly upon selected disabilities. There tends to be a hierarchy, with physical disabilities at the top, sensory disabilities next, and the great variety of intellectual disabilities below. And within the intellectual disabilities, further hierarchies. The sheer numbers of people who have or fear aging conditions capture attention, as do people vocal in their protests at the way that psychiatric services may have treated them. There is a danger of neglecting people with less prominent intellectual disabilities. To test our systems, we have to take these marginalized people and put them at the center. A good test of a system is to see whether it performs best for people who are most marginalized and who need it most. Differences in priority reflect in different starting points for relevant legislation: the elderly in Japan, people with significant learning disabilities in New Zealand. The second diversity is in the historical perspective. My remit today is comparative, not historical, but two historical themes are relevant to a comparative understanding. One is the diversity of perceptions and objectives that lawmakers have tried to answer. The other is the repeated importation of child law concepts and their application to adults. In Scotland, we imported the Roman tutorate law for adults in 1585. In 1913, we created a form of plenary personal guardianship, guardians' powers being defined by reference to the guardians of young children. The purpose was to remedy lasting injury to the community caused by learning disabled people at large in the population. That was abolished in 1984 in favor of a statutory guardianship with fixed and narrow interventionist powers, aimed at ensuring protection and support, but used as a last resort in problem situations. That left a gap filled by non-statutory developments until our present regime ensued in 2002, specifically rejecting the child law concept of best interests. Today, we face unprecedented challenges, but they are welcome, for they challenge us to do better. Many are driven by international and regional instruments and the debates surrounding them. In a world of increasing mobility and of incessant difficulties facing vulnerable people in cross-border situations, we have the disgrace that the Hague Convention 35 on the International Protection of Adults of 2000 has been ratified by only 9 countries. In Europe, we have the challenge of compliance with the European Convention on Human Rights, including Article 8, respect for private and family life, and Article 5 on deprivation of liberty. We have the problem of apparent incompatibility between that Article 5 and Article 14 of CRPD. and we have the challenges presented by CRPD itself, to which I shall return. The third diversity is among the regimes in different countries. In the British Isles, we hit diversity before we travel further. England and Wales is a common law jurisdiction. Incapability renders acts and transactions voidable if the other party is aware of the incapability. It uses a best interests test and gives automatic statutory protection for anyone intervening without formal appointment on a best interests basis. Scotland is a civil law country. Incapability results in voidness regardless of who knows what. A best interests test was rejected in favour of statutory principles, and any similar automatic protection was rejected. England's legislation focuses on decision-making, Scotland's on acting as well as deciding. England has a specialist court, Scotland doesn't. But Scotland has a statutory regime to protect and support any adult who is vulnerable and at risk. England doesn't. England has fixed forms of power of attorney, Scotland doesn't. Scotland has ratified Hague 35, England hasn't. Ireland has a further 2 jurisdictions, both the subject of more recent legislation taking account of CRPD. Moving out into the wider world, we find that wherever there is scope for diversity, there is diversity. The following is a brief distillation of the valuable information from your responses to questionnaires, also responses to previous questionnaires for other purposes. Comparison of key features shows a complex interplay of various centres of emphasis, rather than distinct groupings of uniform regimes. My comparisons are descriptive, not evaluative, nor comprehensive, but may help to stimulate our thinking. To start, at what age are people adults? In Scotland, 16. In the rest of the British Isles, 18. In Turkey, 18, but 15 by court declaration with parental consent. In China, 18, but at any time from 16 if earning their own living. Elsewhere, 21. For non-integrated indigenous people in Brazil, minimum 21. Next, are adults with intellectual disabilities nevertheless, in some respects, treated as children? This can happen explicitly. In Slovenia, parental rights can be extended and an adult equated to a minor over the age of 15. In Brazil, persons determined to have partial capacity are equated to 16 to 18-year-olds. Then there is a group of arrangements and provisions which could be seen negatively as infantilizing adults or positively as respecting the importance and strength of the family. Firstly, we have automatic ex lege family representation for all or some purposes in Argentina, Austria, Czech Republic, Japan, Netherlands, Norway, South Korea, Spain, and Switzerland, with proposed introduction in Sweden. Secondly, there are presumptions in favor of close relatives for appointment of guardians. In some cases, importantly, the adult's own choice takes priority. Austria, Brazil, China, France, Netherlands, Turkey. In Scotland, there is a presumption in favor of relatives only for joint appointments. More broadly, we hear echoes of child law in adult provision. The two-tier childhood in Roman law provided a ready-made response to concepts of general incapability and limited capability, as in the influential structure in France, with loss of legal capacity under tutelle and with a degree of advice and or supervision in entering important transactions, but no incapacitation, under curatelle. This takes us to a group of questions centered upon the concept of incapacitation. Some regimes have incapacitation followed by appointment of a guardian. In the following examples, incapacitation is by a court, but appointment of a guardian is, in China, by the neighborhood committee or the villagers committee. In Hong Kong and Malta, by a guardianship board. In Russia, the Regional Social Care Authority. In Slovenia, the Social Work Center. In Estonia, there is a different division: restriction of legal capacity and appointment of a guardian by a court, or curatorship established by the local municipality. Norway has guardianship with deprivation of legal capacity by a court, or guardianship without deprivation of legal capacity by the county governor. There are combined procedures of full or partial incapacitation and appointment of a guardian in Argentina, France, Taiwan, and Turkey. In Finland, the appointment of a legal representative may be backed by restriction of capacity if that is necessary to protect the interests of the adult. In many countries, too many for detailed analysis here, there is no explicit incapacitation, and indeed, as here in Germany, provision that appointment of a guardian has no effect on legal personality and status. However, in many such countries, and for understandable protective reasons, at least in economic matters, the adult has no competence within the scope of the guardian's powers without the consent of the guardian, raising the question whether in practice powers are accurately aligned to incapabilities. One would reasonably expect better alignment with specialized courts, such as exist in England, Germany, and the Netherlands, or in Australia's specialized tribunals. It may also be helpful for a court to be explicitly given an inquisitorial role, as in Germany. In some jurisdictions, an appointee has explicit power to object to the validity of a purported act by the adult, for example, a supporter in the Czech Republic. Finally, we have guardianship concepts extended beyond cases of intellectual disability. In Turkey, as a criminal punishment. In Brazil, non-integrated indigenous people. In the Netherlands and elsewhere, financial incompetence or prodigality. Shortly, I shall leave you tantalizingly in mid-air, as I have similar comparative material on questions such as, what are the criteria which appointees must apply when acting? What arrangements exist to supervise guardians and to support them? What autonomous measures are available, private mandates or powers of attorney, and the potential to extend power of attorney documents to cover supported decision-making and co-decision-making, advanced directives, trusts for administration. How frequently do countries revise their legislation in order to keep it up to date? The published version of this talk will cover all of these. In all such matters, there is as much diversity as in those which I have described. But let me now draw my large bundle of diversities back into the universality of human rights. We all look forward to hearing shortly from Theresia Degener, representing the UN Committee on the Rights of Persons with Disabilities. I have published significant criticism of some of the committee's comments. Let me counterbalance that by summarizing part of my own contribution to the final report of the Essex Autonomy 3 Jurisdictions project. The UN Committee has been criticized for offering neither precise definitions nor precise instructions as to how safeguards within Article 12 should be operationalized. Instead of regretting that, we saw it as an opportunity. Article 1 of CRPD says, "The purpose of the present convention is to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for their inherent dignity. For that purpose to be achieved, it must become the shared objective of the whole of human society. Within each jurisdiction, we have to take ownership, not thrust responsibility back upon the UN Committee. Its role is to consider, suggest, and make general recommendations. We must each structure support and safeguards that will work and deliver them in practice. Diversity will continue, but targeted towards the common project of realizing Article 1, not random diversity for historical reasons." Let me conclude by reverting to the key phrase, "Respect the rights, will, and preferences of the person." How strongly are will and preferences respected? The primacy of autonomous measures over guardianship and other responsive measures is emphasized by ministerial recommendation in Europe. There is serious under-provision and underutilization of autonomous measures, which must be remedied. Even under autonomous measures, operation raises issues about respect for will and preferences. Across all types of measures, we see isolated shafts of respect, like sunbeams through a cloudy sky. I have examples far beyond the time now available. Some will appear in the written version and will be reviewed tomorrow. We need to deliver respect comprehensively and effectively in practice. We need to develop and apply techniques such as constructing decisions and reverse jurisprudence. In the Essex Autonomy project, we concluded that the existing regimes in England and Wales and in Scotland are non-compliant with CRPD, but remediably non-compliant. Our recommendations included an attributable duty to determine will and preferences, provision of adequately funded advocacy services to support people to overcome obstacles to exercise of legal capacity for themselves, or alternatively, to identify and articulate their will and preferences. Support all aspects of the exercise of legal capacity, not merely communication or decision-making. Development of the full potential of autonomous measures and of clear definitions and robust safeguards to comply with Article 12.4, extending CRPD compliance broadly across all areas of legal systems, and establishing regular monitoring and review. I shall leave you with the text of the recommendation which we put at the head of our list. Respect for the full range of the rights, will, and preferences of everyone must lie at the heart of every legal regime. That must be achieved regardless of the existence and nature of any disabilities. Achieving such respect must be the prime responsibility of anyone who has a role in taking action or making a decision with legal effect on behalf of a person whose ability to take that action or make that decision is impaired. The role may arise from authorization or obligation. The individual with that role should be obliged to operate with the rebuttable presumption that effect should be given to the person's reasonably ascertainable will and preferences, subject to the constraints of possibility and non-criminality. That presumption should be rebuttable only if stringent criteria are satisfied. Action which contravenes the person's known will and preferences should only be permissible if it is shown to be a proportional and necessary means of effectively protecting the full range of the person's rights, freedoms, and interests. Almost all of the regimes which I have reviewed appear to be non-compliant with CRPD, but remediably non-compliant. We have work to do. Thank you.